All right, well, thank you very much. I noticed the recording just started. I am Patrick Priest, the co-chair of the Management and Labor Advisory Committee, or MLAC, for the management side. And it's my pleasure to welcome everyone to our meeting on March 31st. And we'll go ahead and officially begin. And I will turn it over to Kara to take a roll call.
All right, good morning, everyone. So I see Patrick, Lynn, Sarah, and Tammy. John, are you on, Mackenzie?
Can you hear me?
Oh, there he is. Yep. Good morning, John.
I'm on. Good morning.
And then Riverside, Scott, Marcy, Margaret, Jill, and Matt. And I'm not sure if Andrew is on. I don't see him. He may be joining us later.
Okay, so it sounds like we have a quorum. Is that correct, Carol? We have a quorum? Okay, thank you. Thank you very much. Well, I wanted to, as we start each meeting, or the last two, to I want to thank everyone for their time, effort, and participation in our work before us today. I want to recognize that it is very difficult and important work, and I appreciate and value the perspectives and professionalism that everyone brings here today. So thank you very much. And now that we officially have a quorum and we have an item of business, it is my unfortunate role to announce that we are not going to act on the minutes, which is the first item on the agenda where we need a quorum. And that is because there are some, the minutes were distributed and some edits came in that were more than a little bit. And so it was decided that maybe they would be redistributed to allow people to review them again. I don't know if Carrie, if you had any feedback on the minutes themselves or the edits.
Mr. Chair, that's correct. Also, we actually inadvertently put that they were the February 17th minutes instead of the March 17th minutes. so technically we put the wrong thing on the agenda. So if anybody has any additional edits, please send them to me or Baba, and we'll send out a new version with the next packet for the next meeting, and we'll just do 2 sets at the next meeting. So
okay, all right, sounds good. Thank you very much for that. And I think we can move on to the agenda, which I've got here. We have department updates coming up next.
Correct, and we have no updates, so we can skip along.
Okay, there we go. We're zipping right along. We're moving into the legislative review. And the first item that we're going to discuss is Senate Bill 418, which we have talked about in the last couple of meetings. And I understand we have an update on amendments. And I see Joe Basler there. Joe, did you have any comments about the amendments? And
no, we took, yeah, I mean, I do have a comment. So taking the concerns, not concerns, but the suggestions that we had the last meeting and sort of outlining the 2 things you would like me to add to the bill. Christian, ATC gave me language, and so we amended it into the bill. The bill passed committee unanimously. It's going to be carried by Senator Bonham. But yeah, we took everything that you said to do in there, and yeah.
All right. Well, thank you for that. And I noticed attached to the agenda is a link to the bill. I guess this is the amended bill that was adopted, and I read through it, and I noticed that it definitely talked about limiting it to compensable, appointments related to compensable injuries. That was clear to me. The one thing that wasn't clear to me was the that an insurer may ask for some kind of form or something like that. Can you maybe point out to me where that is in what was handed out to us? And I see Scott has a question too.
Joe, I think it's in the -4
I was just gonna say, Chair Priest, that
Mhm.
I think I looked it up on the Oregon Legislature's website on OLIS, and there's a -4, and it does have I think bottom of page 3, it does mention an insurer may require a worker to confirm the period during which the worker is absent. That kind of language is lined out. I think it was Kirsten with AGC that had kind of recommended
Yeah.
that. So I did see that on there. I know that I think the link in the agenda is just to the bill is introduced. So yeah, but I did see that, but I'll let Joe if he has any other details on that.
It was in the dashboard. The dashboard amendments took all of the original amendment that stripped the bill way down, and then all the other parts that Safe had brought up, and then the language Kirsten had given me were all incorporated in the -4s, and that's the bill that moved. That got incorporated in the bill, and that is what moved forward in the the Senate Bill 418A.
Okay, thank you for that clarification. It just wasn't in the link. So
Oh, no problem.
it was listed elsewhere. And I see Scott that very nicely put a link, which I imagine that's to the dashboard. Thank you, Scott. Are there any other, I see Kara, you had your hand raised. Did you have?
No, that was an accident.
All right. I'm
Trying to do
ready.
too many things.
Ready. I'm looking for hands. Are there any other questions, comments, concerns? Kirsten, you went on video. Did you? Is there something? Just you wanted
No,
to be seen? Okay, it was nice.
No,
to
I didn't have anything in particular. I just thank you to Joe for working through some of the language with us. And yeah, I just pulled up that the -4, and I think that language looks good. So thank you, Joe.
All right, thank you. Thank you very much, Joe and Kirsten and everyone on the committee for coming together on a compromise to make sure this bill passes. It sounds like it was unanimous and should move forward. All right, I don't believe that we need to act on anything, Kara. We had talked about this beforehand. It's just we're following up on what we had requested to see the amendments, and we have. I'm hearing no comments or questions, so I'm going to move on unless anybody quickly raises their hand. All right, and I'm not seeing anyone. So thank you, Joe, and I see he's quickly exiting. But all right, we will move on to the next item on our agenda, which is House Bill 3412 regarding the Physician Associate Authority. There's also a link on the agenda, and DCBS did send us a letter that Safe drafted. It is written by Kevin Barrett, and I know he is on the call. I don't know if Kevin, you wanted to talk about this letter that you sent regarding this bill. Kevin, I can't hear you though. You're not on mute, but I can't hear you.
Might have to go out in the meeting and come back in, Kevin. Gonna do that. Well, while Kevin's doing that, I'll just give an update on the status of the bill. So the bill passed out of House Business and Labor Committee, I think a week ago, with the -1 amendment, which had quite a few changes in it related to lining up nurse practitioner and physician associate authority. Subsequent to that, some folks, we have a lot of statutes in a lot of places, moving parts. So Safe had identified some additional areas that might need some clarification. So that's the memo we sent you late yesterday. It's also posted on the MLAC website, so for the public.
All right, I see Kevin back, and I saw his mouth move, but I still didn't hear anything. So I don't know. Hey, David, I see that you got your hand raised, and I can hear you really well.
Okay, I can briefly just say that what was going on with those amendments is, as we all know, nothing is easy in comp. Everything is complicated in language and drafting. And so just as we had some further review, I know that the division found issues earlier and were resolved in the -1, and we found some minor issues that just to make the bill do what it was that everybody intends it to do. And it had to do primarily with MCOs and come along providers, meaning, wanting to ensure that the physician associates would have the same ability to continue treating if they were allowed to come into an MCO, which was an authority that they wouldn't have had without some of these technical changes. So, these are really technical perfecting changes that only a lawyer could love. And I'm not a lawyer, so I don't love them, but I appreciate them. And so, with that, I'm happy to answer questions as best I can, or have Kevin, if he can get on, answer questions, but there's very minor technical pieces.
I noticed in the chat, for those who don't have access, that Kevin Barrett, who's having some technical difficulties, that David summarized his letter very well. Are there any questions from committee members?
I'm not sure, Taylor Sarman, if you wanted to say anything. He represents the physician associate.
Okay.
I saw him. There he is.
Yeah, no, co-chairs, I don't have anything to add other than really appreciate SAFE's help in tracking down some of these places in statute to really align with what you all intended, with the goal of aligning with nurse practitioners. So we're supportive of the changes and what's outlined in the letter, and that draft amendment is already in queue, and so happy to share it with the committee when we get it.
Sounds good. So it sounds like this is an item that will be carried forward to the next meeting, and so there's no action at this time, but I guess since we're all gathered and we've got the information, is there any other comments, questions that anybody has, any feedback as they finalize it? All right, well, good. You're an agreeable group today. That's good. All right, the next item on the agenda is House Bill 3541, related to employer liability. And this was introduced last time. And as I understand it, we have some representatives from Avis here to explain a little further.
So Greg Peden and Mr. Muse, there's Greg.
Yeah, good morning, everybody. This is Greg Peden, the contract lobbyist here in Oregon. For Avis, I spoke with you all a couple of weeks ago. Nice to see you all again. Our bill, just to refresh everybody's memory, comes from a lawsuit that Avis was involved in Multnomah County, where the issue here at hand is the employee of a subsidiary company of Avis was involved in an on-work accident. The court ruled that in this situation that the workers' comp was not the exclusive remedy, and that the employee could bring a lawsuit in Multnomah County court. We think that our bill would seek to remedy that we think that's a erroneous decision from the court. Obviously, we provide the coverage to all of the employees in the corporate family and the corporate structure. Think that that's the right policy. We want to have our employees covered. I think I referenced last time the employee is represented by the Teamsters Union. We believe that they are supportive of the bill as well. The bill, just to also refresh your memory, the bill is sitting in the House Business and Labor Committee. It's scheduled for a work session or to be voted on Monday, but the chair of the committee is waiting for some guidance from all of you. So whatever you decide will greatly affect whether the bill moves forward or not. We sent you the court filings. One of your members had requested that. We sent that into Kara right after we last discussed. I don't know if folks have had a chance to look at that or have had any, would like to have any specific questions answered from us And that's really what we're here today for, is to answer any questions or dig in any further that you would like. And Robert Muse is on the call with me as well.
Thank you, Mr. Peden, for that update. Maybe I'll turn it over to Mr. Muse to give us any additional color before we open it up for questions.
You're gonna match them up, babe? Thank you.
I got
I think
it.
that's just a straight comment. I don't think that was a question for you.
No, it's not.
Robert.
Good morning, and thank you for the opportunity to speak with MLAC this morning. As Mr. Peden noted, it's always been our intention and desire to cover all of our employees through every one of our entities through workers' comp. And we have policies in place that do that exactly. In this particular case, the individual who was injured was involved with a shuttle operation. And because he was a union employee, he was assigned one corporate structure. The people that actually manage the location and decide where cars have to be are in a different corporate structure. And because of that, the courts turned around and said the employee had the opportunity to sue the other corporate entity. And we just think that that doesn't make any sense, that workers' comp should be the exclusive remedy to an employee injured while in the scope of employment.
Thank you. I see that we have our first question from Tammy Bowers.
Hi, Robert. Thank you for coming to talk. Can you elaborate a little bit for me, please, regarding these two corporations? You worked for one and sued another. How those two are related to each other, and why both of them should be protected under exclusive remedy?
Sure, they are all subsidiaries of a parent company. As you can well imagine, we have a wide variety of business things that we do. We have entities that deal with the titling of cars. We have entities that deal with various types of employees for a variety of reasons. As I indicated, the car services company, which was the employer of the injured party, is really designed to ensure that all of our shuttle drivers who are unionized are in one place, as opposed to a mixing and matching. And the management of locations and management of the process of where we want cars based upon supply and demand reside in another place. It's really an employee-based thing as opposed to anything else. But again, they're providing the service for the overall entity. So the service of the car shuttler is providing a service ultimately to the entity that needs the cars to be able to rent. They're all interlinked. So because of the interlink of a parent company, they should all get the same benefit of the workers' comp protection.
I'd like to follow up if that's okay.
Yeah.
Okay, so, which is why I re-raised my hand. Let me lower it now. Okay, so it wasn't like a subrogation. I want to really understand this. I am all for exclusive remedy and want to continue to protect that. And if this needs to be expounded, the exclusive remedy needs to be clarified or expanded upon. I really would like to ferret that out and understand that. And so the effects of the claim or the actual cause of the claim, is this like a subrogation issue? One entity hit in a vehicle accident, another?
So what happened in the accident was several employees were in a van being transported to pick up cars. That van was involved in an accident caused by a third party. While there are claims against the individual tortfeasor, arguably, the employee brought claims not only against his employer, AB Car Services, but he also then brought a claim against the other company of Avis, and the court allowed that to stand.
Okay, so he had his workers' compensation claim, and then he had the subrogation claim against the third party, and then he had a liability claim against like the parent company of
Correct.
the other. So
Correct.
3, okay. All right, I think I understand a little bit better, and I understand where you're coming from. Okay, thank you very much.
You're welcome.
All right, are there any other clarifying questions? Scott Strickland.
Thank you, Mr. Chair. So in reading through a lot of the case documents, the accident occurred in 2019. Is that correct?
I believe that is correct, yes.
And the case was settled in 2022.
Correct.
Is there a reason why we're only just now hearing about it? I know that this has been an issue, that this is a relatively weighty decision with a lot of information for us to wade through. And I know that we've got a lot on our plate, and to kind of dump this on us with an expectation of a turnaround in a day, as was done last time. Has there been some kind of new development or something else that has made this rise to a level of urgency that wasn't previously the case?
I'm not sure I follow the question. I mean, the decision to settle the case from our perspective was made last year, and then we decided to seek a legislative clarification in 2023.
Okay.
So technically we would have had to decide whether or not we wanted to appeal all the way through the court system. We got the indication that was not going to be a fruitful exercise. So rather than litigating and then reducing our costs and the cost of defense, we made the decision to settle. But ultimately, we wanted to see if there's clarification so we don't have to go through this again. I mean, we've been in business 70 plus years, and this is really the first instance that this type of case has come up.
And how long in the 70 years have you had the sort of entity structure that led to this development?
We've had multiple entities for as long as I'm with the company, which is 29 years.
All right, I see Marcy Grail with her hand raised.
Thank you, Mr. Chair. I've been trying to read and keep up, and I think this is a very complicated issue. In my experience in my workplaces, we find more and more opportunities for parent companies to continue creating additional businesses. And what I'm concerned about is trying to track down the rabbit hole on behalf of the workers. And so I would just like to put on the record that I'm concerned, and partially it's because I feel like I need more information. I have not spoken to, I think the gentleman, I don't know which one, I'm sorry, I don't recall which of you said it, but that the Teamsters endorsed this. I haven't talked to anyone in Teamsters, and I would just like to understand more. And there's a lot of attorneys available to ask questions to, which I will happily do at another time. But I don't think I understand all the connected dots, perhaps from management perspective. I just see it appearing like more barriers to get remedy. And I might be misunderstanding, so I'm not trying to make a decision or anything. I just want to be clear that there's a lot of questions that I have, and I'm not sure that I can articulate them yet.
All right. Thank you, Ms. Grail. Do you have any response, our Avis representatives? None? Okay. All right, there's another comment, a couple more. They're coming quick now. All right, so Sarah Beckwell is next.
Thank you, Chair Priest. I also would like clarification on the Teamsters endorsement. So if someone could answer that for Marcy and myself right now, if that's possible, Chair Priest, if you could ask.
Okay. Is there a follow-up item from our Avis representatives, either of you, on the Teamsters endorsement?
I don't know if anyone's on from Teamsters.
Robert, can you answer that at all?
We have reached out to the Teamsters. We have not heard any objection from them, so we do believe that they will be supportive. They did not take a position in the litigation.
Okay, all right, well, that's a little bit different than what I had heard the first time around. I don't, Kara, very good question, asking if somebody from the Teamsters is on the call. I'll wait and see if anybody speaks up and let them voice their own opinion.
I'm not seeing anyone.
Okay, thank you, Kara. All right, so I saw a couple of hands go up and go down. I don't know. The only one up now is Tammy Bauer, so I'll call on her next, but anybody that wants to speak, I'll let them. Go ahead, Tammy.
Okay, I'm not speaking on what was just being talked about. So if anybody wants to talk about that, I don't want to jump ahead of the subject. My concern that I would like to just kind of, I guess, make a comment about is that, if the parent company is paying for the workers' compensation claim, the injured worker has an accepted work comp claim and is getting, indemnified for anything that they've lost. And then the parent company has to now pay a separate liability claim as well. They're having to pay for the exact same thing twice. And that just does not seem fair to me. And that is why one of the reasons why we have exclusive remedy. And so I'm not sure that pushing this through right now is the appropriate thing to do, because there is a lot in here and we like to really study this. But I do think that this bill is definitely worth merit to go into and carve that out. We don't want a company paying twice on the exact same claim. That's not right, especially if they have now also a subrogation claim. 3 claims for one thing does not seem like it just breaks the principle of indemnity, in my opinion. Okay, so that's my comment.
Thank you for that comment. Very good one. All right, Lynn McNamara has her hand raised.
Hi, thank you, Patrick. I just want to echo what Tammy said and what Marcy said too, that it is a very complicated issue that is, in my opinion, certainly worth discussing over the interim, but it's pushing it through now is not a reasonable thing to do, especially since we heard about it for the first time only at the last meeting. So that's my 2 cents. Thank you.
All right, thank you for that comment. I know go ahead. Scott Strickland has his hand raised.
Go ahead, Chair Priest. I'm happy to follow you.
I think my comment was to call on DCBS. I'm new, relatively new, but I don't know, maybe everybody's new. It's a complicated system, this work comp, and bringing bills before MLAC, and maybe just a little, Greg and Robert, it's my first time seeing you before this committee, and maybe it would educate us all, Kara or DCBS, somebody, to talk about the normal process of bringing a bill before MLAC and workers' comp bills and what the normal process is. We've had a lot come forward at the last moment, but what is the proper time frame, if there is one?
I don't know that there's a specific time period. I mean, each legislative session has their own. I'm sorry, there's a chat message from John McKenzie, if you want to look at that one talking.
Okay, I will. Yeah, I'll go ahead. I'll read his statement after you respond, Kara.
There is no set schedule. Legislative sessions happen every year. Bills are developed, in anticipation of those sessions. I think this was an unusual one because of the change in administration and a lot of new members. So there have been some late coming bills just because of that. Process has taken longer because there were a lot of bills being drafted, so things were slower. It's when we see bills that are on chapter 656 issues, we call them to your attention and get them scheduled as quickly as we can. So there is no set schedule, and this has just been an unusual session.
Okay,
Mr. Chair, could I add a comment to that?
Certainly, go ahead.
Great, thank you. This is Greg Peden, the contract lobbyist. I just wanted to kind of add to what Kara just said. We introduced this bill, beginning of session, got the language out of legislative council, I'm going to just say off the top of my head 6 weeks ago. And Kara's absolutely right. I mean, as we all understand, there's a process that we have to go through at the legislature that we aren't necessarily in control of, right? When we submit the language to LC, there are literally thousands of other bills getting processed and developed by LC. Once we got the language back, I was contacted by Representative Bashar Davis, who I think had outreach from Kara or somebody as part of her team saying, can we come before MLAC and have present this issue? So we can respect the concerns that everybody has raised here, that this is complicated and haven't had a lot of time to digest it. I think we're all kind of maybe beholden to the legislative process and timelines on all of that. We are up against a deadline here, and I know that that's you're aware of that, and trying to make decisions, all of that. I would want to add just back to what the representative from May Trucking said, that she articulated it very well. That is exactly the issue, is that should this be under the dynamic of exclusive remedy or not? And we're happy to work with all of you going forward to answer all of the questions that you may have, that you currently have, and other questions that you may have going forward. But that's ultimately what we think is the question before you, right? That's this lawsuit has created that dynamic where we're saying, gosh, we thought we were doing this right, and the court says we're not. And that's why we're sort of bringing this forward as saying, okay, well, what are we supposed to do here? Because the idea of paying twice doesn't make sense to us, seems to be against the policy of why we have workers' comp to begin with. We're trying to figure it out. So I just wanted to kind of add on that and appreciate the opportunity there, Mr. Chair.
Yeah, thank you. Thank you very much for that. I wanted to read into the record that John McKenzie has put into the chat. He's a management caucus member, that he agrees with Tammy and Lynn's statements. He didn't need to unmute, but wanted to share his support for the comments made by his fellow caucus members. All right, I have a couple of more hand raised, and Scott Strickland is first.
Thank you, Mr. Chair. I agree too. I am fully in support of the exclusive remedy. I think that's all the grand bargain and compromise that we've talked about. I think a little bit of the problem that I'm having with this is this seems like there was some gamesmanship with entity formation that was done and structured in a certain way to achieve certain goals. And the whole point of the exclusive remedy has to do with the employer. It doesn't have to do with investors and protecting investors. So the idea of having an employer pay more than once, yeah, I agree, exclusive remedy matters. And that's, the keystone to this whole system. But I have a little bit of a problem if the Teamster represented employee, well, I should put it this way. If the employee of the other company was also a Teamster represented member of the same company, we wouldn't be running into this issue. Or if there was a company policy that did not allow transportation of other companies' employees, we wouldn't run into this issue. So it seems to me, and I may be misunderstanding because this is a complicated case, but there's a slew of 20 or so different options that could have happened that would not have led to the result of a parent company having to pay twice theoretically. But I would argue, coming from the construction environment, there's all manner of times where you're on a construction site where there's multiple different employers, where you have general contractors, project owners, other subcontractors, suppliers to subs and other things like that, that may be related in some way or another, that if I'm injured and it's not the negligence of my employer, obviously there's exclusive remedy for my employer. But if there's some other employee whose negligence led to the injury, classically, especially in construction, that's always been allowed, because again, the exclusive remedy is limited to the employer. And it's not intended to protect investors and to protect other corporate entity structures. And I know that there was some question with the analysis from DCBS about the way that this was drafted. It doesn't really clearly define, related employers and other entities and what that means. Does that mean preferred stock? Does that mean voting stock? Does that mean a certain percentage? Does that mean control? Does that, all of this to me, I agree exclusive remedy is a good thing. That's the keystone of our foundation of what we do here. But I feel like that it's missing the point that it's exclusive remedy against your employer. I don't know, Mr. Chair, if there's anyone that would like to elaborate or could kind of clarify on that.
Yeah, that you laid out a lot there. Very, very eloquent. Thanks, Scott. Do we, either of our Avis representatives have a response or follow up to Scott's comments?
Robert, do you want to respond at all?
I think the answer for me is that they are employees of the company. This is not protecting shareholders as in that context, and they're not independent contractors. These are entities structured for specific reasons in the operation of our business. They are all employees, although they may be an employee of AB Car Services versus AB Car Rental, but they are all employees of Avis Budget Car Rentals Inc. through a chain, right? It's all a chain. The workers' comp is covering every employee in every entity, and we shouldn't be subject to a lawsuit because we have the coverage for the employee, and it should be the exclusive remedy. That this is not the independent contractor scenario. If we retain an outside service to shuttle cars for us, which we do from time to time, they have their own workers' comp, and we insist on that, and we wouldn't have this issue.
But I guess a very brief follow-up, if I may, Mr. Chair.
Yes.
Who is paying the workers' comp insurance premium on those employees?
It comes from the parent company. They hold the policy, and it covers every entity.
Okay. All right. I have one more question hand raised from Sarah Duckwall.
Thank you, Chair Priest. More comments. We've had a lot come through, and I appreciate some of it is we're all beholden to the process, and timing isn't ideal. I'm encouraged that everyone, agrees with the concept of exclusive remedy. And I'm hoping going forward, maybe Kara can help with this, that if MLAC has a certain set of questions that we want, as a starting point or jumping off point for concepts or bills to come to us with as many answers as possible, I think it could really help the process going forward. And I think this is definitely something we need to continue to work towards addressing, not this session, but next.
Thank you for that comment. I noticed a couple of hands raised and then went down. I don't know. Don't be bashful. We can address as many as we can. Kirsten, you were one of the ones I was thinking.
I was going to say, I was one of those ones. Well, I was going to follow up on Scott's comment. I think that the construction industry is a great example of sort of a whole bunch of different areas where this could apply. And so I think it kind of goes to that question of diving into the issue of like, in which instances is it in line with the overall goal of the workers' comp system for those to be covered? And in other, I just think that is it's a good case study, I guess, in this overall question of like, because, you have all the subcontractor and general relationships, but then you also have some construction companies that may have, a subsidiary, but, that really is very tied to the main company. So anyways, I was just gonna say, I think that there are definitely questions to dive into in terms of how to make this work within the exclusive remedy, make sure that exclusive remedy is working the way it's supposed to. So
thank you for that comment. All right, any other questions, comments, concerns? All right, because we are asked to act upon something and to consider it, I feel like it is prudent for us to go into caucus to discuss. And I would ask our MLAC administrator to please set that up.
I will do that right now. So I'm gonna pause the recording and send you to your breakout rooms, and we'll be on a brief recess.
All right, thank you. I believe.
I
All right,
started
thank you very
recording,
much.
so we can start.
Okay, thank you very much, Administrator Pilsinger. And we are recording. We are back from our caucus, and the co-chairs did have a chance to visit a little bit, and our caucuses met. And I believe that Scott and I decided to just give a summary of what our caucus opinions are, and then we'll move into comment. So I'll defer to Scott to go first.
Yeah, so I think, in discussions with Patrick, we had a lot of concerns. I know that we're all, sort of beholden to the legislative process, slow as it can be often. But I think especially for me and the Labor Caucus, I know we had some concerns about the timing and about the sort of systemic change that this seems to bring. I think that we're obviously on board with, the grand bargain of the exclusive remedy, I think is fine, and we're in support of that, but really linking that to the employer. And I think that we had some concerns about stakeholder involvement or the lack thereof, not hearing from the Teamsters, not having them present, not having the time to sort of reach out and verify a lot of these things. And, the kind of sweeping changes that it would bring to, the definition of an employer, and the lack of, we had some concerns, I think, in the legislative analysis. I think that was done by DCBS, mentioning sort of the scope of the definition of a parent company or related entities of the employer. And I haven't really seen anything back response-wise to that. So I think those are a lot of the concerns that we had. And I think really just touching on the scope of how this would change how work comp work, is done in Oregon, is pretty profound, I think, to be, this rushed in the analysis. I don't know, Patrick, I'm sure there's more on top of that as well. And I think we might have a couple comments from Labor members as well.
Thank you very much, Scott, for that summary of the Labor Caucus discussion and ours as well. The Management Caucus also feels as though this is a little bit late for a complicated issue to bring forward. And so there are some concerns about that. We are very encouraged and support exclusive remedy. And I feel as though management and labor are united in that exclusive remedy is a very, core principle of workers' compensation, and we can rally around that, and that there are some opportunities in this bill within it, but not as it's presented right now. I think the Management Caucus really felt like more stakeholders needed to be involved beyond just Avis and the industry that they represent, in order to ensure that there is a broad application of this bill. We see it being important for other types of companies and industries, but want to make sure that there aren't unintended consequences by focusing on a single case in a single company. More engagement with us at MLAC. And I think we also talked a little bit about the DCBS write-up, that the bill analysis, and that there were some concerns that did not seem to be addressed. At least it didn't reach us. And so that's the feedback that we would offer. I feel Scott and I and my Management Caucus, none of us felt as though comfortable to vote on anything today and provide a recommendation. However, we wanted to provide feedback in support of the concept and encouragement to bring forward a bill in the future with more stakeholders and more research. So I will open it up for comments, from my caucus, to correct me if I said anything wrong or left anything out, or from anyone. All right, Tammy Bowers.
I don't think you left anything out, but since you said comments, I hope I can make a comment to Robert. And I'm sorry, but I don't remember Mr. Hendon's first name, but yeah, but the one thing that I would like to see clarified in the bill, if you bring this back for short session, is a better definition of what the parent company and related entities is. If we could get that really clarified in your bill and bring it back for short session, that would be great.
All right, thank you, Tammy. Any other comments or questions? All right, Marcy.
You're muted, Marcy.
Sorry. Thank you. Thank you, Mr. Chair. We've been talking for a while now. Does anyone know how Henry is doing?
I don't know. I don't know who Henry is, Marcy.
I think that was the
Sorry.
name of the injured worker.
Oh, the injured worker. Oh, I'm sorry. I didn't know that wasn't part of the testimony. I don't know. It's a good question.
This is Greg Peden. I don't know the answer to that either, but I'm more than happy to try to find out and get back to you.
Thank you.
All right. Well, good follow-up. I would be curious as well. Thank you very much, Marcy, for bringing that forward. We have nothing to vote on, Kara. So I guess if there are no further comments, that is the end of our business, unless there are any comments or questions from those that brought this forward of us.
I would just say we will definitely, regroup and reorganize and definitely look forward to working with you all in the interim with the idea of bringing it back more fully vetted next year. And I appreciate all of the input.
Thank you. Thank you for that. All right. Thank you. Administrator Filsinger, is there any other business to be brought before our committee today?
I believe so, no.
All right. I would seek a motion to adjourn.
So move.
Thank you, Sarah. Is there a second?
Second.
Lynn, second. Maybe Marcy's off mute. Did you second as well, Marcy? No?
Nope, it's fine. I was just preparing.
Okay. All right. All those in favor signify by saying aye.
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 All right. I vote aye. Are there any opposed? Okay. The meeting is adjourned. Thank you very much. And I give you 48 minutes of your life back.
Thank you. Happy Friday.
Thanks,
Aye.
everyone.